This video is part of a series intended to help citizens, members of the media, public officials, or anyone acting on their behalf to better understand Florida's exceedingly broad Public Records Act. These videos may be used by anyone and may be freely distributed without charge. I am not an attorney. I am not qualified, nor am I authorized to give legal advice to the public, so I don't. Any information provided by me in person, on video, or through fogwatch.org is readily available from the Florida First Amendment Foundation and the Florida Attorney General's Office of Open Government, as well as many other sources online. What conditions may be placed upon access to public records? Only those prescribed by law. Section 119.07, Parent 1, Parent A of the Florida Statutes establishes a right of access to public records in plain and unequivocal terms. Every person who has custody of a public record shall permit the record to be inspected and copied by any person desiring to do so at any reasonable time, under reasonable conditions, and under supervision by the custodian of the public records. The term reasonable conditions is the most misunderstood and misapplied phrase in the context of public records access. According to the Florida Supreme Court, the phrase refers not to conditions which must be fulfilled before review is permitted, but to reasonable regulations that would permit the custodian of records to protect them from alteration, damage, or destruction, and also to ensure that the person reviewing the records is not subjected to physical constraints designed to preclude review. The Florida Supreme Court further illuminated the role of the custodian in 1984 when it opined, "The sole purpose of custodial supervision is to protect the records from alteration, damage, or destruction." Therefore, public agencies are not free to create or implement any policy that serves to limit or restrict access to public records unless such a mechanism has been specifically prescribed by the Florida legislature, and then it must be narrowly applied. In any event, no mechanism may be employed that operates to restrict or circumvent a person's right of access. In AGO 7550, the Florida Attorney General wrote, "The courts of this state have invalidated measures which seek to impose any additional burden on those seeking to exercise their rights to obtain records under the Public Records Act." The custodian of a public record is at all times responsible for the custody of the public records. But when a citizen applies to inspect or make copies of them, it is his duty to make provision for this to be done in such a manner as will accommodate the applicant and at the same time safeguard the records. For more than 100 years, the courts of Florida have been striking down nonsensical attempts to frustrate access to public records. The role of the custodian of public records is to protect the records and to facilitate public access to them. In practical terms, if any policy, practice, or mechanism, which is not specifically prescribed by statute, serves to limit public access to records, it is unlawful, a liability to the offending agency, and a disservice to the public it serves.